Good morning. And good morning to everyone in the courtroom, and I wish everybody a healthy and happy new year. The panel here in your cases this morning consists of the three of us, as you can see. To my right is Justice Eric Neyman. To my left is Justice Peter Sachs. My name is Ariane Vuono. I think everyone in the courtroom knows that you each have 15 minutes to address us with your case. We've read everything that you've submitted to us, and so you can get to your most salient points right away. But I always like to remind everyone that there is no rebuttal in the appeals court in Massachusetts. With that said, I'll call the first case, Commonwealth versus Justin Greaves or Graves? Okay, Greaves. All right, thank you. 2025-0029.
Good morning. May it please the Court. Catherine Jansen on behalf of the Commonwealth. The Commonwealth respectfully requests that the Court reverse the allowance of the motion to suppress. I think the niche issue that presented in this case is whether there was sufficient evidence in the record to suggest that a pat frisk of the backpack was unnecessary before opening it and to do a minimal search based on not only the testimony from Detective Sano, but also the video evidence, which I have submitted to the court, showing that while this was a soft-style mesh backpack as described and found by the motion judge, that it was readily observable and testified to by the officers and seen in the video. It contained, I'm sorry, was there a question?
Yeah. Is the question whether a pat frisk would be sufficient to either confirm or dispel the reasonable suspicion a question of fact?
I think in this case, I think the answer is yes, because whether or not the facts presented would make a pat frisk useless. And so the facts presented in this case, I would suggest, where you can see in the video and through Detective Sano's testimony that the backpack, it was readily apparent that there was this big, large, bulky object. Yeah. And I would suggest there isn't more needed from an officer's testimony or opinion that a pat frisk would have been useless, I think, so long as there's evidence in the record to suggest that.
My question about whether it's a question of fact is, we don't have a finding that a pat frisk would not have been at least useful in confirming or dispelling suspicion, and we don't have any testimony to that effect. So we would have to find that fact ourselves based on what we can see in the video.
Which I think the court can do because it's de novo review for the video. And I would suggest in Pagan, I think this is similar to Pagan opposed to Rutledge, where there was an absence of such facts in the record, where in Pagan, it was clear that the duffel bag contained heavy objects that you couldn't feel. I don't believe from my most recent reading of Pagan, I don't think there's testimony about the fact that, or finding that it would be impossible for a pat frisk. I think so long as there are facts in the record.
Yeah. So the gun was found in an upper pocket. Do you think we can see from the video that a pat of the upper pocket area of the backpack would not have been sufficient to feel that gun?
I think so. I think you don't know, just because we know that's where the gun was found. We're talking about what the officers knew at the moment when they were deciding whether to pat frisk the bag or open it and search the bag. And so where you know there's a big object that the bag takes the shape of it, you're not necessarily, I mean, if they had seen a bulge potentially from the gun, then we might be in a different circumstance, or if you could see that in the video. But I don't think that's the case where it just appears there's a big object and a pat frisk would be potentially useless. They don't know where the gun is.
So just to be sure that I understand your argument, your point is that we as a panel need to rely on what we see in the video to establish the fact that a pat frisk would have been, you say useless, I'll use the term impracticable as I use in the cases. That's what we need to do in order to agree with your position. Is that right?
I think so, because I think you're just looking, yes, you look at the video and you can make that factual finding de novo or factual finding de novo. I think and Justice Sachs, I did point this out, that the judge he only concentrated on the style of the bag, that it was soft-sided. He didn't go so far as to say that it would be, I mean, he went so far as to say I guess he did find that you could pat frisk it based on the style of the bag, but he didn't talk about what the item was in the bag or that it was boxy. He found that Detective Sano saw there was an Xbox protruding from it. And so I do think there are facts in the record as found and as testified by Detective Sano from which this court.
But additionally, we would need to make our own findings de novo from that video.
I think this court would, yes.
Okay.
And how can we do that here? How can we say that a pat frisk of that bag would not have revealed the presence of the firearm? I don't know that we can do that.
I mean, my reading of the case law is that if there are facts in the record, evidence, whether it be testimony or video evidence, that my understanding of the case law is so long as there is something some evidence in the record that would suggest that a pat frisk would be impracticable. I'm going to butcher that word.
But what in that video shows that it would be impracticable? Look, here's where I struggle with this case. Watching that video, it appears to me the police did absolutely nothing that was unreasonable. They acted quite reasonably. They did their job, for lack of a better term. But yet, the SJC has given us this case law that says, when it comes to containers, frisk first, open second.
Unless it's readily apparent.
Unless it's readily apparent. So, for example, had the bag been, let's say they were looking for burglarious tools, and the bag had been closed and they felt hard objects in the bag just by the weight of the bag and when they set it down. In that situation, you can open the bag because it's evident and obvious that there's something in there that could be the object, but it necessarily, we can't tell. Here, we don't seem to get to that stage because they didn't do the initial frisk, and there was no testimony as to, for example, the weight of the bag or how much of the bag was consumed by the Xbox. So again, I asked the same question with that huge windup. I apologize.
No,
but
I understand.
How do we get to the point where we can make that finding here?
I would suggest, and the Commonwealth's position is, I think you can see it in the video that when the defendant walks in, you can see it's protruding, that the bag is taking the shape of the Xbox, and that when the bag is taken off of him and Detective Sano takes possession of the bag, again, you can see it's bulky and protruding out of it, and that a frisk would not confirm or dispel potentially whether a weapon is within it. I think that's all it needs to be. It's readily observable, and I would suggest that this court can find it's readily observable from that video and from Detective Sano's testimony.
At the hearing, sorry.
No, sorry. Just want to follow up. So the point you're making now is that once you see that Xbox, since it's a bulky object, that would render any pat frisk of any of the other compartments impracticable.
I would suggest so, because I think in the video you can see that it's taking the shape of the whole bag, just because the compartments are together.
Well, couldn't you also say that would show that there's probably nothing in, if you think that the Xbox is taking up the whole bag, then does that dispel the reasonable suspicion that there's a firearm there?
I would suggest it wouldn't, because it could be at the bottom of the bag, and so the Xbox is taking out the bag and it's protruding out the side, but it could still disguise it at the bottom, or it could be there could be something else within the bag. I mean, I think the case law is clear that where it seems that it's clear there's something in the bag, and in this case they know it's an Xbox, but there's something in the bag, whether they know it or not know it, it could disguise the presence of something within it.
Okay, so the last question is, if the Xbox was not visible, if it was in the bag.
It was fully zipped.
Fully zipped. Would a pat frisk have been necessary first before the bag was opened?
No, I think in this case, because it was taking the bag took the shape of the Xbox and there was clearly something in it that could be disguising something more within it, and when they had a report of a firearm, whether the bag was zipped or unzipped, I don't think matters in this case.
Is your authority for that Pagan? You say Peg, and I've been taught it was Pagan, but I could be wrong.
I butcher the name of cases, so it could be, I would say it's Pagan, or, yes, that's my authority, and I would just contrast it with Rutledge, where there wasn't evidence. In Rutledge, there was no testimony or no evidence about the bag at all. So I would say there aren't a ton of
Close
cases.
here, too. There's not much testimony about the bag in this case either, is there? We have the video.
Sorry?
There's not much testimony about the bag in this case either. but we
but
have the video.
There's a video, and there is more, from my reading of Rutledge, there is more. There was Detective Sano saying it was soft-style mesh bag, the type of bag, and that she could see the Xbox protruding from it, and then we have the video. So I do think that there is more than Rutledge. Maybe not overwhelmingly more, but there was
So
more.
again, to go back to Rutledge, Rutledge says, in all cases, though, where a pat frisk can establish whether a possible weapon is present or not, courts have required a preliminary pat frisk of the container in question. Again, based on that video alone, how can we say that the pat frisk would definitively not have established whether a possible weapon was present? I don't see how we can say that.
I would
And again, to be clear, from a practical perspective, I don't think the police did anything wrong here, but that's not the issue. The issue is, what has the SJC directed us in cases involving searches of containers?
And I would suggest it's I understand the court's position, and I would.
Not a position, it's a question. We have not taken a position on this case.
I'm sorry.
Just to be clear.
Yes, the question about how you can find that from the video, and I would suggest that's the evidence in the record, and I think that is enough evidence we're pagan, and I did find an unpublished opinion that I'm happy to provide a 16L letter to the case from this court. I found it late last night, so I didn't have a chance to.
You can just give us the name and the.
Yes, it's Commonwealth v. Abdul Hussein. I will spell that, ABDULHUSSEIN. It's 105 Mass App Court, 1106, a 2024 case, and the docket number.
Actually, can you give us, is the case number on the top of that?
Yes, it's 2023 P704.
704, okay.
Yeah, sometimes those sites are
Take a look
hard to
at it.
find. And in that case, a panel of this court found, again, it's unpublished, it's persuasive. The process of removing a bag from the defendant made clear that the bag contained a hard, heavy item. There was no need for her to pat frisk the bag prior to opening it. Although the court in Pagan recognized sufficient police control of the bag and the bag might be removed in exigency, it did not decide the issue in that case.
In that case, was the bag closed?
In that case, the bag I believe it was closed, and it was a bag around the defendant's neck, draped in front of his chest. It was about 1 foot wide, large enough to hold a handgun, and composed of soft material.
Does it matter that in our case, the bag is open and what is protruding is not a weapon? So, in other words, the police can see that there's an Xbox in there. So, knowing that, doesn't it make sense under Pagan for them to frisk first? And again, I hate to tell police how to do their job, but that's what the SJC has directed us. To frisk first, and then either you feel the gun or you say, we can't tell, and at that point you open the bag.
I would suggest no, where I think my understanding reading of the cases is that if you can't, just because you know it's an Xbox doesn't mean that a weapon might not otherwise be disguised by feel. So just because you know, if you're frisking it and say, well, I can't tell, you're with the same information as before. And I would suggest, based on the video, this court can find that would be the outcome of a frisk prior to this. That it would be impracticable because it would give them no more information than they already have, regardless of whether the bag was zippered and they didn't know it was an Xbox, or in this case where it was unzippered and they could tell it was an Xbox.
Well, actually, I want to get back to just Sachs had a question.
Yes. At the evidentiary hearing on the motion, when the Commonwealth was still pursuing its inevitable discovery argument, the trial court ADA said if the detective had frisked the bag, she certainly would have felt the firearm. So I'm not going to suggest that that's a binding concession, but doesn't it at least suggest that for someone viewing the video, as she must have, it was not readily observable that a pat frisk wouldn't suffice?
I'm not so sure that, I don't know if that's necessarily true. I think oftentimes trial ADAs are making any and all arguments possible off the cuff, and I think that she was just trying to justify the police actions in any way possible. The Commonwealth, obviously, as the court understood, and I recognize that the court understands, the Commonwealth's not bound by that argument, and we pursued this argument in the motion to reconsider.
Well, it really could have gone either way, right? A pat frisk could have also said, there's absolutely nothing here but an Xbox, you know? Presumably, because the police knew that he was going into a hotel, there's some sort of toiletries or something else in the bag. We can assume that. We can reasonably make that assumption. So something would have been felt, and they could have easily said, "Well, just an Xbox, and that's it." So your argument can really go either way, I guess, right?
Correct, Your Honor.
Before you only have 6 seconds, did you want to say anything about the fact that there was a danger because a gun could have been loaded, or do you want to leave that in your brief?
I would be happy to leave that in my brief. I don't think that's the winning argument of the day.
Okay, I'm going to see if the panel has any further questions. No, thank you very much.
Very much.
Good morning.
Good morning. May it please the Court, Edward Crane on behalf of Justin Greaves. The motion judge correctly allowed the defendant's motion to suppress. At the outset, it is important to reemphasize the standard that the SJC adopted in Pagan. The police can only proceed directly to a search of a container if it is minimally necessary to determine whether there is a weapon inside. It's the Commonwealth's burden to establish that a search is minimally necessary. Applying this standard here, the motion judge correctly concluded that the Commonwealth failed to establish that a search of the defendant's backpack was minimally necessary to determine whether there was a weapon inside.
So you just cited Pagan, correct? Pagan says at page 70, I'm reading from, it's a lengthy sentence, but let me read the relevant portion. It says, if a pat frisk reveals a hard object near the surface, we're talking about a backpack or bag here, soft bag. If a pat frisk reveals a hard object near the surface, the bag will have to be opened to retrieve it, or if the pat frisk uncovers no hard object, the bag will still have to be opened to determine whether a weapon is hidden deeper inside. So if you pat frisk and you find a hard object inside an unopened bag near the top, it seems to me the SJC is saying, well, then you can open the bag in that circumstance to see whether or not the object you're looking for is actually there. Are you with me?
Yes.
Here, the bag is already opened, and we already see that there is a hard, large object near the top. So why is it in circumstance A they get to open the bag, but here where the bag is already open and there is a hard object near the top, why can't the police take the same step under our jurisprudence?
I think the difference between hypothetical A and hypothetical B, well, not hypothetical B is our case, but the difference is that in the first situation, the police don't know what the hard object is yet. They don't know if it's a weapon, could be a weapon. So further investigation is required to determine if it is a weapon. In situation B, they know what the hard object is. That here they know it's an Xbox, so they know it's not a weapon. So that's why those two situations would be different.
So they're allowed to undertake further investigation in hypothetical B now, which is our case. They're allowed to take further investigation, and you're saying it's limited to feeling the bag, right?
Yes.
Okay. It seems to me, having watched the video, that if the police start manipulating this bag, they can manipulate it for several minutes and feel and learn everything about that bag and what is inside of it. Whereas here, they open, they unzip, they zip, they unzip, they zip, and that happens in a period of about 5 seconds. Why is the latter more intrusive than the former?
Well, I think the latter is more intrusive because when you look inside the bag, you discover its contents. You know exactly what's in the bag. Whereas feeling the outside of a bag, you don't necessarily know what the contents are.
Even if you manipulate it, because there's no time limit under our case law, right? The police can manipulate that bag for several minutes and literally like squeeze and poke and find everything that's in there.
Yeah.
And in the latter situation, again, the video shows, I said 5 seconds, it's maybe even closer to 3 seconds where they went zip, unzip, zip, unzip, zip. Hey, there's a gun in there.
Yeah.
It seems that arguably the latter is truly less intrusive under the particular facts of this case, and I'm struggling with that.
Well, I guess I would just go back to just a situation where
Sight into a dark bag revealing one is more intrusive than manipulation and feeling all of the objects in there over a period of minutes? Seems like a strange line to draw to me.
I think that the frisk, though, the frisk of the bag is just, it might reveal sort of the weight, the feeling of an object, but not necessarily what that is. And I guess
But it might reveal everything. In a a thin bag, you can tell all sorts of objects that are.
Well, I guess I don't think that you can't be sure of what it is. It's not feeling something from the exterior. I mean, I guess this is the reason why we have pad frisks in the first place, is because they're they can reveal whether there's potentially a weapon there, but they won't reveal exactly, more personal things. That, if it's not a weapon, they won't reveal exactly what it is that might be on an individual's person. And I guess that case was cited in the Commonwealth's brief. Commonwealth v. Fleming is an interesting example, I think, for this particular situation, where in that case, the police, instead of doing a pat frisk, they lifted up the defendant's shirt and to determine whether he had a weapon in his waistband. And the court actually concluded that that was more intrusive than a pat frisk itself. And I think that rationale sort of plays out here, where, and the court dealt with that. They said, look, this is actually less intrusive in terms of physically intrusive, because a pat frisk would be more physically intrusive than simply lifting up someone's shirt. But where it's more intrusive is that it shows what actually is there, and that's more intrusive than just the pat frisk, where you're feeling what it might potentially be. And I guess another example might be just if you have something in your backpack, so not this particular case, but if someone has something in their backpack, I'm struggling to think of what a great example would be, but something embarrassing in their backpack, right? I don't know, let's say maybe...
Sex toy.
Thank you, Your Honor. That's a good example. So,
Personal
sex toy
hygiene
in your
items or
backpack.
something like that.
What's that?
Personal hygiene items, if it's a woman, something like that.
Yes, Your Honor.
I'm not going to offer any suggestions, but go ahead.
Thank you. I think your compatriots have already supplied the perfect hypotheticals for me, so thank you. But something like that, where a plain feel is not going to be able to determine what that actually is, whereas looking in the bag, a personal hygiene item, looking in the bag, that is going to be revealed. So I think that's where it is more intrusive.
So let me ask another question. Assume that, I think it was Detective Sarna, assume that the police officer here did briefly frisk the bag and didn't feel a gun. Could she have then unzipped it in this case and checked, gone to the next step?
If she briefly frisked the bag and didn't feel...
Frisked the bag and said, I can't tell. Didn't feel a gun.
I don't think so. So I think that it goes step by step. So the pat frisk is the first step. If the pat frisk, it doesn't necessarily have to be you can pat frisk someone, and it doesn't have to. You don't have to be 100% certain that it's a weapon to proceed to the next step of searching. But if the pat frisk suggests that there's a hard, heavy object in here that could be a weapon, then you are allowed to proceed to the next step. But if you pat frisk something and there's nothing in there that you don't feel anything that could potentially be a weapon, then that's where the search.
Assume she pat frisked it and said, I can't tell because of this big Xbox in here if there's something else in there or not. Are the police, who have reasonable suspicion to believe that this person is armed and dangerous and does not have an LTC, can they then open the bag?
I think the next step would be to remove the Xbox. I think that's the minimally intrusive next step, would be to remove the Xbox, then pat frisk the bag.
That would be a second pat frisk then.
Yes.
Isn't that requiring a little bit more than the cases require?
I'm sorry, Your Honor?
Doesn't that require more than our cases require? To actually remove one object, zip up the bag again, and then pat frisk again, and then determine whether or not there's anything in there that's suspicious?
I don't think so, because I think what Pagan speaks to is that the steps always have to be what is minimally necessary to accomplish the goal of determining whether there might be a weapon inside. So if the pat frisk at first, if the pat frisk is done and the police officer determines, like, I pat frisked this bag, but this Xbox is creating a real problem. I cannot determine whether there's something else in this bag because of this Xbox. I can't properly pat frisk this bag. The next step, that would be the next minimally intrusive step, would be to remove the Xbox. I don't think you have to zip the whole bag back up. Just remove the Xbox and then pat frisk the exterior of the Xbox. I think that's less intrusive than opening the compartments and looking inside.
Well, that's a logical explanation and has certainly as a compelling one. But what it does ignore is the sort of the fluidity of the circumstances. I mean, they're not at the police station where they have the bag and they can take their time and everyone's milling around and they can look at it carefully. They can pat frisk, zip up, pat frisk, whatever they need to do. What happens here is when they're in a small vestibule of a hotel. And, you have to keep into consideration the fact that things can move kind of quickly in that kind of environment. So what are the police supposed to do in that kind of actually, this is our hypothetical, not even hypothetical, this is our case. They're supposed to have taken it out, closed it up, checked it out. That's what you think should have happened here?
Well, I think that if this is a situation where the law has to prevail over, I guess, sort of
that's a good
more.
point.
I would concur that with Justice Neyman's point earlier that the police did nothing wrong here. This is a difficult standard, I think, to carry out in practice in terms of, in reality, are the police going to be thinking about the Pagan standard when they get to this backpack? Probably not. It's unlikely. But there needs to be, that is the law is laid down. That's the standard that's applicable, and we have to apply that. And I think another point here, though, with respect to the situation here, I think it would be different if this was, say the defendant was actively resisting, if this was what they call a rapidly deteriorating situation, or just a situation where there was exigency involved, that there was some sort of if there was a crowd around, if this was a situation that was more tense, then I think potentially the police looking in the backpack.
Well, what of the fact that 3 different times they had to tell him to put his hands down on the counter? First time they said, put your hands on the counter, he does. He then turns away from them, so the backpack is away from the officers, and they say again, put your hands down, and he puts his hand down, and then a third time he does it again, and then the officer grabs his hand and puts it down for him. So A, he's shielding the bag, and B, 3 times he's not putting his hands down, when again, they have reasonable suspicion to believe that he is unlawfully carrying a firearm and he's a dangerous person. So why don't those facts rise to the level of saying to the police, yeah, he's either got a gun on him or in that bag?
Well, I think there's a difference between this situation and a situation where the police truly aren't in control. And in this situation, yes, the defendant removed his hands and the police moved them back to the counter. But by the time
Twice.
Yes, Your Honor. By the time they're looking in the bag, he's under arrest. He's been handcuffed. He's standing there. He's not creating a ruckus or resisting really in any way. He's just standing there. So by the time that the search is done, there's no. I wouldn't say that this is the type of situation that involves some sort of exigency or public safety situation where they wouldn't be able to.
There's a public safety issue here. I don't agree with that. But in any event, your case really boils down to this. Your case boils down to they skipped a step here. Is that correct?
Yes.
Okay.
And candidly, as you said, that the law has to, I think your point was the law has to prevail. The law requires a step, and that's the step.
Yes, the
Right.
Pagan standard is applicable here, and I think that Pagan is a pretty clearly applicable here. It's a straightforward application of Pagan.
All right. Any questions on this side? Any further questions? Thank you both very much for the argument. This is a tricky case, and we appreciate your answering all of our questions, and your briefs in the case were very well done. Thank you very much.
Thank you.
Okay, the next case on our list is Commonwealth versus Jerome Leatherwood, 2024-1254. Morning.
Morning, Your Honors. If it please the Court, my name's Ethan Stiles, and I appear on behalf of Mr. Leatherwood today. And I appear because he should never have been found competent to stand trial, and certainly not by the time he actually stood trial. Now, in this case, one expert found him competent in 2018, and I believe the judge relied upon that. And in two subsequent essentially motions to reconsider, she and the other judge, who would turn out to be the trial judge, essentially said that no, nothing's changed. He's still competent, even though by the time between the competency initial and the trial, almost 4 years had lapsed. And I am arguing that the competency finding was stale, and it should have been revisited properly at the time of trial. Now, in this case, the Commonwealth has the burden to show that that the defendant is competent to stand trial at trial, and in 4 years, a lot can happen. In fact, I'm not sure if Your Honors had received it, but I filed a 16L letter yesterday.
We have it.
Okay, and I just wanted to point out that in that decision, it deals with a different type of defendant who defended herself pro se, something I would suggest that Mr. Leatherwood had no chance of doing. But anyway, one curious note in that case indicated that Dr. Burrell, who was also the one who found him competent in this case, they said it was interviewed 2 years afterward, and the court did not think that was particularly relevant as to the competency of the defendant at the time of trial. I just wanted to note that. It was just a coincidence. And I thought it was
I have a
worthy.
question for you. It's a little bit in a different context. And that is, what strikes me about this case is how well your client testified at trial. Every question did not detour from the defense theory, able to actually correct the Commonwealth, the prosecutor, at least twice with respect to certain questions. The trial judge right there watching everything as it goes along. What do you say about that?
And I think that tends it down to the surface level, because we have never said that he can't recite basic facts. He knows where he lives. He can get by.
These were not just basic facts. This is reciting and explaining his behavior and conduct, and protesting his innocence.
Yes, and to that extent, he can think concretely. He can think of facts. He knows, who, he's not. That's not where the real focus, I think, should lie. The focus needs to lie on his ability to make decisions and assist his attorney, and his ability to control himself when he's dealing with a traumatic.
Stop right there. So he was able to assist his attorney to decide that he was going to testify on his own behalf, right?
He did make that decision, yes.
Okay, an important decision, maybe one of the most important decisions a defendant might make at trial, right?
However, it should be noted that, that was one important decision. Now, there are other important decisions, and I believe it has been noted that he has a very trusting relationship with his attorney, and that's certainly something that I have, I've interacted with him during the course of this process.
Well,
and in this particular case, there are unusual circumstances in terms of taking an appeal, which usually aren't present. In a normal appeal, you say, okay, the evidence was insufficient, and if the appeals court agrees to be terrific, my conviction's quashed, or I get a motion for new trial, and that's allowed. Okay, we know what's going to happen. In this case, the consequences, if the court did find that there was error, are not so clear, and therefore it's difficult to guide the defendant to say, do you want to take an appeal or do you not? And obviously, those are conversations that have had difficulty, Well,
I don't think we should concentrate, if I may say so, speaking for myself, not the whole panel, on decisions that your client made with you after the fact. What we need to concentrate on is whether he was competent at the time. The record shows the Commonwealth has met its burden of showing that he was competent at the time of trial,
Yes.
right?
And
in that, let me say, we can also include the fact, not just his decision to testify, but then his decision to accept a plea with respect to subsequent offenses.
You see, but that also is not without its problems, because there was no plea colloquy in this case. I couldn't find one, and I looked. And, there should have been one, I believe, but there wasn't. So ultimately, the judge never had an interaction with him to determine whether this was.
I think that there was one when he waived the jury trial and went for a bench trial for the subsequent offenses. No?
It might have been, but I don't recall it so clear. I do recall there was discussion about it. I do recall that it was part of a plea agreement, but I don't recall a full-on normal colloquy that a judge has when they're waiving their right. There may have been maybe a waiver of jury trial, but I don't believe there was a waiver of his actual rights to plead guilty.
I think that's correct. I think there was just a waiver of the jury trial.
It may have been, but but those are the other two big decisions.
That was on March 4th, 2022.
All right.
Okay.
Yeah, so, but the other decisions, it could be suggested with his recognized competency deficiencies, and his ability to make choices, rational choices, which I would suggest are, are overemphasized. They say, for example, when he engages in self-harm, he's doing that for a secondary gain in order to get something out of people. But I would suggest that those are not really good rational choices to make, because he usually just buries himself deeper, because now instead of if he engages in self-harm, he's going to be put in restraint, or if he or he'll be taken away. So I would suggest that that those kind of childish behaviors do not really reflect real competency and the ability to make rational decisions.
I want to ask about the standard here. It's a two-pronged standard, as both parties have recognized in their briefs. Judge Miller found in her first decision, I think, that the dispute was not so much over whether he had a rational as well as factual understanding of the proceedings against him, but it was more about his sufficient presentability to consult with his lawyer with a reasonable degree of rational understanding. Do you think that that's where the real dispute is, over that prong regarding communication with the lawyer?
I believe so, especially in moments of stress. Now, he's had trauma, and no expert has denied that his trauma is genuine. Some might say he overemphasizes. They may use words like he malingers at times. He exaggerates the extent of his deficiencies, but there are deficiencies there, and whatever was said in 2018. I believe that was the only opinion that found him competent, whereas we have a later opinion on which the judges relied upon, the second judge more in particular, from Dr. Leonardo, who said, I'm not sure, I can't determine whether he's competent or not. I think, the suggestions that he is in the data, but I can't make the determination.
I guess what I'm getting at, though, is are you still contesting, or are you now contesting the prong of the test that concerns rational as well as factual understanding, or are you just focusing on the ability to communicate with counsel?
I believe I'm more focused on the ability, but I cannot say ultimately. Essentially, it coincides because he has to make the ability to make rational choices, and if he cannot make it because he procrastinates, he's unable to weigh the consequences appropriately, then yes, it does. Both of those elements, the communication, the rational, the factual, that's not a big issue. I mean, I think Justice Vuono pointed out he was able to speak to the facts during his testimony, but that's what we can see. But what we harder to see, because obviously we don't have a window into his interactions with his attorney, is what is he able to process and comprehend in a very difficult case with outcomes that are rather unclear. Essentially, if he says, okay, if you say in a normal case, okay, if you're found guilty, you could go to jail for X amount of time, and you say, well, the prosecutor's offering X, less than X, that's something, he can understand, but there's more to it in this kind of a case than that. So
we're reviewing the decision for abuse of discretion.
Yeah.
Is that correct?
I believe that's the standard.
What was the abuse of discretion? Did the judge not consider all the applicable factors, or did the judge, despite having considered them, make some choice that was outside the range of reasonable alternatives?
Well, I believe there are two parts to the answer. I mean, first of all, when the judge relies on still evidence that has factual errors in it, then essentially I would argue that the burden is shifted to the defendant to show that he is competent, where the burden must remain on the prosecutor to show that he is competent at all times. So there is that, but I believe that that the reliance on stale or equivocal opinions from the experts can be considered an abuse of discretion. Even the judge I would argue, made an error about his, for example, when she found that he had engaged in self-advocacy at the recovery center, she relied on evidence which she later struck. I think he reached out to legal services to complain about his treatment provider, and she later struck that. So it's just that is error that should not have been relied upon in this case. And of course, also the fact that we have this 4-year window of time where we don't know what's going on with him, because from 2016 to 2018 he was at Worcester Recovery Center, right? And that was the best placement for him. He wanted to stay there, even though he had an antagonistic relationship with the head there. He was doing this best. Now after that, he gets sent back to places that he hates, that Bridgewater State Hospital or the Suffolk jail, and he's not doing so well. And that goes on for a period of time. Then COVID strikes, and he's able to get out on bail. And at that point, he's not treating. He's not really engaging. With things designed to maintain whatever level of restoration he might have had. So I think the judges in their at least by the second reconsideration motion, should really didn't put proper consideration to that issue.
So the judge Judge Sanders, right before she made her competency determination, had an evidentiary hearing, heard from Dr. Laniato. Dr. Laniato wasn't able to express a conclusive medical opinion because of the suggestion that the defendant might be malingering or intentionally presenting a false picture of his mental functioning. But it's a legal question, competency, not a medical question. So is the fact that Dr. Laniato was equivocal, does that preclude the judge from saying, based on what I'm seeing and the medical evidence before me, I'm deciding as a legal matter that he's competent?
Well, I believe that judges, judges generally aren't psychological experts. They haven't had, and these judges had not had a great deal of opportunity to interact with Mr. Leatherwood at that time. Essentially, they didn't have any lengthy colloquies with him. There was obviously some discussion in there's some exchanges in the transcripts, very brief ones, but ultimately, the judges have to rely on the evidence before them, and I would suggest that, when you're considering a person's competency in 2022, and all you have is stuff that's really old and dated by that point, and this equivocal indication from someone who hadn't seen him since 2020, I think she indicated that she had seen him just at the dawn of COVID, when that happened. I feel that there's just not enough evidence there to say, okay, in 2022, I find he's competent, given all that had transpired since 2018. So ultimately, that is where I stress that the greatest chance of error in finding him competent was present.
You have a discussion in your brief, a brief discussion where you note that the trial judge may not have been or was not privy to certain difficulties that trial counsel may have had communicating with his client with respect to waiver of a jury trial, whether or not to take a plea, whether or not to testify in his own defense. Is there an affidavit in the record from trial counsel describing those difficulties anywhere, or was there any testimony from trial counsel detailing those difficulties?
What I can point to you, Justice Neyman, is that there was at the first day, the jury selection I took 2 or 3 days, right? Between the first and the second, there was an incident where he was under I think he decompensated, emotionally dysregulated. I think he was making threats for self-harm around the end of the first day. And the second day, I believe the trial counsel did raise the issue with the judge, and I think she also submitted a letter from a Dr. Soleil, I think it was, and indicating that that there's some serious issues here, but the judge pretty much decided to soldier on with the trial. And that's the best record evidence I can point out to you, Judge.
Thank you.
Well, all right. Well, if there are no other questions, I would just like to end on an observation, namely that I think it would be ironic if the court were to find that that the judge was right on competency based on applications of factual considerations and legal principles, which I believe that Mr. Leatherwood would have no hope of understanding. Thank you.
Further question? Thank you very much. Counselor?
Good morning. May it please the court. Molly Paris on behalf of the Commonwealth, asking this court to affirm the defendant's convictions. Here, Judge Miller and Judge Sanders were well within their discretion in finding the defendant competent. There were 3 competency hearings here, but I'll focus on the last competency hearing before Judge Sanders, as that was less than a month before trial and would be most relevant in assessing the defendant's competency at the time of trial. Judge Sanders considered the live testimony from Dr. Sarah Lanadino. She considered 16 exhibits, and contrary to counsel's suggestion, Judge Sanders made detailed findings as to her own observations of the defendant, how he would act out when things weren't going his way and otherwise appeared calm and appeared to have a good relationship with his attorney.
What is your response to the staleness argument?
The response would be that Dr. Burrell's report was but one factor in the judge's ultimate determination of competency. The judge also had before her Dr. Lanadino's expert report, which considered interviews with the defendant, conversations with his attorney, all of his medical records from Bridgewater State Hospital, Worcester Recovery Center, records from his childhood, his legal records, an extensive body of material that she considered in assessing his competency. And so it just wasn't Dr. Burrell's report. And again, even if there had been several experts finding the defendant incompetent, and it wouldn't necessarily be an abuse of discretion for a judge to find the defendant competent if, say, their in-court observations or expert reports suggested otherwise. So their decisions here were not outside the range of reasonable alternatives. Judge Sanders also properly considered the defendant's jailhouse calls and his interview with police, which further suggested his competency. She credited Dr. Lanadino's expert testimony, which suggested that the defendant was grossly exaggerating his cognitive and emotional limitations that he was presenting in one way towards evaluators and another way in other aspects of his life, and that despite his cognitive deficits, those wouldn't impact his competency-related abilities. And again, just that there was this disconnect by how he would behave with evaluators and how he would behave with other members, say at Bridgewater State or Worcester Recovery Center in his day-to-day life. And yes, so again, Dr. Burrell's report was just one factor that was before Judge Sanders in finding the defendant competent. And again, this was less than 1 month before trial. And to Your Honor's point earlier, the defendant did testify ultimately in his own defense at this case. Unless the court has any further questions.
Do you think that abuse of discretion standard makes sense in a situation like this?
In a situation like this.
Reviewing a competency determination. I mean, in Vuono, which is where the standard seems to have originated, the SJC was talking about reviewing a decision on a motion for new trial, which involved competency, but they sort of announced the standard in connection with reviewing the typical standard for motion for new trial. And then that was kind of expanded in subsequent cases to encompass review of the competency decision itself. But I'm wondering why we don't review factual findings for clear error and review for an error of law.
Well, I think the factual findings wouldn't be reviewed for clear error only because this court gives deference to the judge's ultimately credibility.
Erroneous, I'm saying clearly erroneous review gives a lot of deference to the judge's factual findings, but it is a different kind of review than just looking at abuse of discretion.
I think abuse of discretion is proper here, especially where the Commonwealth's burden at the competency hearings is by a preponderance of the evidence, which is an extremely low standard. So considering that and all the material that's in front of the judge, whether it be the live testimony, the documentary evidence, I hadn't considered that question, but I can't think of another standard that would be more appropriate. and that's the one that's been accepted.
I wanted to ask about the denial of funds. The judge denied funds for a couple of reasons. One of them was that the speech-language pathologist is unlikely to find that the defendant was incompetent. Is that the right question, or is the question whether the speech-language pathologist might have something to say which, in combination with the other evidence about competence, might tip the balance?
I think the appropriate standard is whether the defendant met his burden in showing that that funds for a speech-language pathologist would likely result in a meritorious grounds for a new trial. And so I think when you look at here what's in the defendant's motion and his submission from current appellate counsel that a speech-language pathologist could apply to the defendant here, there's no showing, there's no affidavit from trial counsel or from any expert or new research to suggest that this speech-language pathologist would opine that the defendant was incompetent. And even to the extent that they did opine that, nothing to suggest that a judge would then credit that in their ultimate determination of competency, where again, the expert's opinion is one factor in a judge's ultimate determination of competency. And again, where his competency was extensively litigated, there was no doubt that experts acknowledged his cognitive deficits, but as Judge Miller and Judge Sanders found, those cognitive related deficits and his language-based deficits would not impair his competency-related abilities. So I just simply think the defendant did not meet his burden here. Unless the court has any further questions, I'll rest on my brief.
Any here? Thank you both very much. Okay, this brings us to our third case this morning, which is Commonwealth versus Brian Vines, also known as Brian Davis, 2024-1257.
Good morning, Your Honors.
Morning, Counselor.
Police Court. My name is Attorney Paul Brennan, and I represent the defendant appellant Brian Vines in this matter. This is an appeal from denial of a motion for a new trial. In the motion for a new trial, the defendant alleged that he received ineffective assistance of counsel in connection with jury impanelment involved delicate questions of racial bias. Also, he received ineffective assistance to counsel in failing to object to improper closing arguments of the prosecutor. I'm also appealing from the sentence that was imposed on May, I believe it was May 21st, 2021. We contend was an illegal sentence because when we appeared before Judge Davis at the time, we submitted a sentencing memorandum which he refused to entertain, and that was improper.
Right.
So do
you want to begin with the juror issue?
Yes, I would like to
Okay.
get to the jury.
All right.
But I was just outlining the issues that were involved in this appeal. Now, I want to make clear what we're asking for here today. It's not asking for a motion for a new trial to be allowed, and we're just asking for an evidentiary hearing. And
You're not asking us to,
in other words, we asked for an evidentiary hearing,
Yes.
and which was denied, and that's what we're seeking here. today.
All right, so your position is that we can't decide the motion for a new trial unless there's an evidentiary hearing?
That's
with
correct,
respect?
yes.
Okay.
We said there-
And the issue there really is focused on what communication a former counsel gave to your client with respect to juror number 3?
Well, there are two issues. First of all, there was his failure to challenge juror number 3 for cause or exercise
peremptory
a peremptory challenge. And we believe that it was improper to seat that juror, looking over.
I just want to back up for a second. Would you agree that the decision whether or not to move to strike that juror for cause or to use a peremptory challenge are tactical decisions which are reviewed for being manifestly unreasonable?
Well, no, I don't think you can, with due all due respect, I don't think you can view it as a tactical decision unless you think that seating a racially biased juror is a reasonable tactical decision. Question
But
is,
you're jumping to the conclusion. I'm saying that the actual decision the decision to decide whether or not to use a peremptory challenge or the decision whether or not to ask a judge to strike a juror for cause, are those tactical decisions?
my contention is, respectfully, Your Honor, if this juror was racially biased.
Well, of course, but is it a tactical decision first, and then we'll go to the second issue?
I don't see how you can get there. If he's racially biased, there's no tactical decision that can justify seating him, that juror. That's simply it.
Sure, I'm not going to argue with you about your point. I understand what your point is, but let's just say, for example, the evidence shows that this juror was hypothetically not racially biased. Still in all, the decision to use a peremptory challenge or not, is that tactical or not in your
Well,
view?
if he finds that the juror, if it was reasonable to find that this juror was not racially biased, yes, I suppose, exercise.
I just wanted to clarify that,
Right,
okay.
but
You also have a juror issue on direct appeal, don't you? Say that the judge erred by asking the wrong question.
that's correct, yes, okay.
It's not just a question of counsel's tactics or.
Well, yes, okay, so.
In addition, you also say the judge should have excused that juror sua sponte, and that's part of your
Yes,
direct
yeah.
appeal as well, right?
Yes, yes.
Okay. There's
Okay.
some crossover, but we'll be able to
Right,
sort
well,
that
okay,
out.
but I think I do think, first of all, it was ineffective assistance of counsel not to strike that juror, and I do contend that the judge should have sua sponte struck that juror. But I want to, at this stage, concentrate on the issue of whether or not Attorney Benziken was obliged to consult with my client about what this juror had said and what Attorney Benziken disclosed to my client, because that pertains to whether or not my client exercised an informed and intelligent choice to agree to sit that juror.
So suppose that the judge credited Attorney Benziken's affidavit in which he said that he told the defendant of the juror number 3's maybe response on the question regarding race, but then, this is quoting the affidavit, but then conveyed by impression of the juror, given his follow-up response, and suggested to the defendant that we should keep the juror. Okay. Is that, if the judge credits that, does that nevertheless demonstrate ineffective assistance?
No, because the rulings of the motion judge are not pertinent here. This court has to independently review the record. This was not the trial judge, and that's
No,
number
I'm
one.
asking if the affidavit is credited, then is that sufficient to constitute competent performance? I told the juror, this is paraphrasing the affidavit, I told the defendant of the juror's response maybe to the question about race, and then I conveyed my impression of the juror given his follow-up response, and I suggested to the defendant that we keep the juror. Is that sufficient?
No, okay, well, first of all,
Does defense counsel have to report to the defendant verbatim what the prospective juror said?
okay, first of all, the findings of the motion judge are not relevant here. The court
Not
has.
talking
No,
about
he's
the
not talking about findings.
Okay, all right. Right, no, okay. So if you credit the affidavit of Attorney Benziken, it's still insufficient. Now, I'm not saying that Attorney Benziken was required to report verbatim what that juror said, but he was required to report the sum and substance of what that juror said, including reporting to my client that he had said that he believed that black men were more inclined to commit a crime.
But according to the affidavit, he did say that.
That's not what he said. Now, in the affidavit, he just said he had answered maybe in connection with matters pertaining to race. He did not say specifically that this juror said that he believed that black men were more likely to commit crimes. And
He didn't actually say that.
Record Appendix, Volume 2, page 10. During jury selection, juror number 3 answered maybe to a question as to whether a black person was more likely to commit a crime than a Caucasian. And then he goes on and describes his review of the transcripts. In light of the follow-up questioning, I thought the juror listened well to the judge, and I believe that he would be a conscientious and attentive juror. I returned to counsel table, told Mr. Vines the juror responded maybe to the jury question on race, but then conveyed my impression of the juror given his follow-up response. I suggested to Mr. Vines that we should keep the juror.
Yes, but he doesn't say that he told Mr. Vines that. The question is whether he says that he was present, Attorney Benzigen was present at sidebar when he heard this juror respond to the questions during voir dire, but in his affidavit, he just said that he told Mr. Vines that that this juror had responded maybe in connection with matters pertaining to race. So unfortunately, the affidavit...
jury question on race.
I'm sorry?
To the jury question on
jury
race,
question on
which
race.
is specified earlier exactly what the question was.
I'm sorry?
Go ahead.
Okay. So in other words, unfortunately, the affidavit of Attorney Benzigen is so vague that one cannot reliably determine what he told my client. My client says he never told him that this juror had stated his opinion that black men were more likely to commit a crime because of everything that's going on, etc.
That's the second time you have made that point where the record does not support that that observation. It was a response to a question. The juror number 3 did not, on his own, sua sponte, say that he believed one thing or another. He just answered the question that was posed to him. Am I wrong about that?
Well, yes, he has to respond to the question that is put to him, but if I just...
So it may very well be that the colloquy at sidebar was not sufficient to determine whether or not this juror should have been seated. That's something you may want to address now by responding, maybe. You make a point in your brief that that was not sufficiently definite response. But I don't think that you can say much more about the fact that counsel addressed the issue with your client at the time.
I think that based upon the affidavit of Attorney Benzigen and what my client has said, there is a sufficient basis to conclude...
For an evidentiary hearing.
In other words,
All right.
who's telling the truth? Now, I would just respectfully submit that Attorney Benzigen's affidavit is vague, so vague that we can't reliably determine just exactly what he told my client. My client says he never mentioned the word about... mentioning anything about black men being more likely to commit crimes, and if he had been aware of that, he certainly would have objected to seating of that juror. Now, the next question is, well, and this goes to the question of prejudice, if he had been informed of what this juror had said, would he have made if he had decided not to seat that juror, would that be a rational choice? That's not a question of how strong was the evidence. That's irrelevant here. The question is whether or not, and this is the question. This is how prejudice is evaluated in this case. If he'd been adequately informed about what this juror had said, would his decision not to seat this juror be a rational or reasonable decision? I respectfully submit it would have been. Now, you can say it might have been a rational decision to seat that juror, or you might have a different opinion and say, no, it wouldn't have been a rational decision. That's something for a motion judge to decide after he hears the testimony of Attorney Benzigen and my client. I respectfully submit that it can be disputed that if my client had decided not to seat that juror, that would have been a rational and reasonable decision. Now, you may have a different opinion about that, but ultimately, the decision the right to make that decision belonged to my client. In the remaining time I have to me, I would just like to briefly address the question of the sentencing. There's no dispute that my client was appeared at, on May 21st, 2023, my client appeared for resentencing pursuant to the order of Judge Moriarty because he decided that that the initial sentence he had received was illegal. So when he appeared for resentencing, we submitted a sentencing memorandum, and we asked the judge to...
Let's just back up. You disagree that Judge Moriarty actually entered a ruling on that issue, is that correct?
I don't think you can sentence anyone in a written ruling, okay? Sentencing has to be in court, okay? So Judge Moriarty...
Let me be more clear. Do you disagree that Judge Moriarty entered a ruling on your motion for a new sentence because of the original sentence being illegal?
Yes, the original sentence was illegal. He acknowledges that. So he vacated the sentence, and then he indicated that, in his opinion, what my client should receive, and that's his opinion. But as to what sentence should be imposed, as for the sentencing judge, Judge Moriarty had retired. He was no longer sentencing.
Well, when he ruled on the motion, he was still working.
That's correct. But again, because he rules on a motion and says, I
see your point. You're saying that the ruling on the motion was not the equivalent of a sentencing hearing.
That's correct.
So is your claim of error that the judge did not afford an oral opportunity to be heard to either defense counsel or the defendant?
Yes, that's correct.
Is that the only error that you're claiming with regard to the sentence?
Well, as far as we can't, because he didn't entertain a sentencing argument, I can't get into whether he should have imposed a different sentence. All I contend is that my client was denied the opportunity to submit a sentencing argument and receive a sentence different from what Judge Moriarty recommended.
At the time when your client moved to correct the illegal sentence, clearly that memorandum was arguing that the defendant should have had a parole date set, in essence.
I'm sorry, Your Honor?
That the defendant should have had a parole date set,
Yeah,
a minimum. So wasn't that an opportunity for the defendant to say, and here's what it should be?
We did. Actually, we did. I submitted a sentencing memorandum. I indicated to the motion judge we were asking for a parole eligibility date of 20 years instead of 25. The judge wouldn't even entertain that. He indicated, and if you look at the record, he said, I have no discretion. Judge Moriarty...
I think you're talking about before Judge Moriarty.
Yes, I was talking about before Judge Moriarty. But let me back up even to the initial sentencing. Defense counsel said, I came in here thinking this case was governed by 25A, in which you do have to set a parole date. And the Commonwealth agreed with that. And the judge said he read it differently. But wasn't that the defendant's opportunity to argue as to what the parole date should be? And I don't see that he made that argument.
Okay, so I looked at the record. The Attorney Benzigan represented the defendant at the time. He did not ask a specific parole eligibility date. It was somehow, neither did Judge Moriarty indicate a parole eligibility date. It was just left up in the air, and that's where I determined that somehow the sentence was improper, because there should have been a parole eligibility date set.
Well, yes, Judge Moriarty later decided that he should have set a parole date originally, but wasn't that the defendant's opportunity to argue as to what the parole date should be?
There was no hearing on it. It was all on written papers.
No. I'm talking about the original sentencing. At the original sentencing, defense counsel says, I came in here ready to argue that this case was governed by 25A, which allows for parole, not 25B, which does not. And there was discussion with the Commonwealth about the Commonwealth initially thinking there was no parole, but having been persuaded by Attorney Benzigan that yes, indeed, the defendant should be eligible for parole, or was under 25A. So why, at that point, didn't the defense counsel at least have an opportunity to argue as to what that parole date should be? Judge Moriarty had not definitively announced that he was not going to set a parole date at that point.
Well, I think both counsel for the Commonwealth and the defendant and Judge Moriarty dropped the ball. They should have set a parole eligibility date. They didn't. And that's when I brought a motion for,
Yes, but you're arguing that the defendant didn't have an opportunity
Yes.
to be heard on that.
Yes.
Why wasn't his opportunity at the initial sentencing hearing?
well, I mean, I don't think he's waived that. I mean, the fact that everybody dropped the ball doesn't mean my client has waived it. Now, the sentence was, Judge Moriarty agreed it was an illegal sentence, and he had to be resentenced. And when we went for resentencing, Judge Davis refused to entertain a sentencing argument.
But Judge Moriarty actually changes his sentence in that ruling. Why isn't that sufficient?
Because
Why
you
isn't
can't
been fixed?
sentence anybody. You can't sentence somebody in a memorandum entered into court. It has to be in person, and that's why we went in front of Judge Davis on May 21st, 2023.
What's the law that-
I've never seen any instance.
Let me just ask you, Justice Sachs, I think is going to ask you, what's the law on that? But one more question. Judge Davis does say to your client that even if I had discretion, I would impose the same sentence.
Yeah.
Why doesn't that take care of the problem?
Well, I would just draw your Honor's attention to the case of Commonwealth versus White.
Okay.
Okay, he does have discretion, and he was improper. I mean, on the Commonwealth versus White, that was something he shouldn't have said.
Okay, so my question, you answered my question. Thank you.
Okay.
Any further questions?
Just before I go, Your Honor, I just want
No,
to...
I'm sorry, your time is up. Nothing will be waived. Everything is in your brief. Thank you very much.
Good morning. If it pleases the court, Arne Hansen for the Commonwealth of Massachusetts, representing the Plymouth County DA's office. I
Morning.
would ask that you affirm the defendant's conviction and deny his request for an evidentiary hearing regarding the issue on what advice was given during jury selection. With respect to the first issue, it's clear that this is being evaluated, or seating a juror is a tactical decision. Commonwealth v. Segoya, 53 Mass Appeals Court 184, clearly states that. That's a 2021 case that's cited in my brief. Where there are tactical decisions pursuant to Commonwealth v. Gonzalez, those are evaluated and only deemed inappropriate if they're manifestly unreasonable, which really isn't the case here. With respect to the contention that, the defendant's contention that defense counsel didn't give a very clear affidavit as to what he did with regards to the selection of juror number 3. I don't think that's borne out in the record. I think it's actually the opposite. Attorney Benzikin gives a very detailed affidavit of what he did with that specific juror. And in his affidavit, he states that he reviewed the jury pool questionnaires with the defendant ahead of time to identify people to use preemptories on. In doing so, they identified multiple people further down the list that they didn't want in the jury pool and that they planned to use their preemptories on. When they spoke with juror number 3, the judge asked the question about racial bias, and the juror responded, maybe. Judge Moriarty then followed up and said, could you put that aside and evaluate this case based solely on the evidence? And the juror responded, I believe so. Contrary to the defendant's contention, that is actually an unequivocal statement. The case law that I cite supports that. The conversation continues.
You would admit it's a bit tricky, though, isn't it?
He
I believe
he says
so.
it twice, though.
I mean, when you're on the cold record here, it's hard for the panel to determine whether or not that's equivocal or unequivocal.
So, and that's fair, but that brings me to later in that conversation. So Attorney Benzikin, having heard the defendant respond, or the juror respond, I believe so, takes it on his own to then follow up on that question. And he asks a follow-up question about why did you say maybe and why did you say I believe so. The juror then responds as to what his reasoning is, and he's asked further follow-up questions by the judge about, hey, notwithstanding your beliefs regarding black men and deaths of police officers, can you put that aside and evaluate this case just based on the evidence? At which point the defendant says, the juror says, I think so. So we have a I believe so and we have an I think so. With respect to, so it's the same response two times, rather than the Clark case that the defendant relies on where that juror doubled down on their racist beliefs, or juror number 2 in this case where they again said that they reiterated their stereotypes that they believed in and said they wouldn't be able to remove those from their consideration. That's not what juror number 3 did here. And I cite to Colton as well as Bannister. In Colton, the juror said, yes, I think so. So that's yes, I think so. Here we just have I think so. And then Bannister, I think I could, as well as no, I don't think it would, were both considered unequivocal. I would suggest the language used here is the exact same or very similar to the language used by juror number 3 in this case. Now, with respect to what Attorney Benzikin then did, so he asked the follow-up question to flush out the issue during the impanelment process, but then he went back to the defendant and discussed the responses, and he ultimately came to the conclusion based on the jurors' demeanor as well as responses that they would be conscientious and attentive, and he wasn't concerned with their I think so response. And as a team, they decided to seat, or he advised the defendant to seat that juror, and the defendant ultimately agreed. So clearly, this isn't manifestly unreasonable. The defense attorney clearly considered what the juror said and then went through a substantial process to evaluate that, flesh it out, and discuss it with his client. This wasn't an oversight. It was clearly a tactical decision. Now, with respect to whether or not the judge should have sua sponte gotten rid of that juror, I've already touched on it. But again, the trial judge is in the best position to evaluate the juror, and largely this is also a question of demeanor, and that's why we defer to them in these cases. But as I said in Colton, yes, I think so, or as Colton said, yes, I think so, as well as Bannister. Again, those responses are similar enough to the responses here. So the judge's decision here isn't clearly an abuse of discretion. With respect to the defendant's illegal sentence, there is no illegal sentence here. He was convicted of armed robbery pursuant to 265, Section 17.
Well, I think what he's saying is that not that the term of the sentence or the way it's structured is illegal, and I don't think he has much of an argument that no discretion was exercised by either judge, but his argument is that he should have had a chance to argue about what the parole date should be before the sentence was imposed, whether it was imposed by Judge Moriarty or Judge Davis.
No, so I understand that, and as the court pointed out, I haven't seen a violation in the law here, so it's a little bit difficult to...
What about the violation of the rule, was it Rule 28?
So my argument here would be that there's a distinction between a corrected sentence, which can be corrected on the papers, which is what Judge Moriarty did here, versus an actual sentencing. So he had a sentencing hearing after his trial where he was sentenced to life. He had an opportunity to be heard. There really, with respect to the sentencing argument, there wasn't really much discretion for the judge, or at least at the original sentencing hearing, because he was an habitual offender, and the judge had to impose life.
Let's take a step back. There's no right of allocution at sentencing, but is there a right to present a sentencing argument verbally in court?
I would argue that he had that opportunity at his original sentencing hearing. The judge...
Not did he have an opportunity. The question is, does our jurisprudence recognize a right to be heard in person, on the record, at the time of sentencing?
Which I think was the case here when he was originally sentenced.
So the answer is yes?
Yes.
Okay.
And so that did happen. The judge was familiar with the story that the defendant was going to pitch. And
Well, no, but at that time, the judge was saying at that time that he was not going to set a parole eligibility date, right?
Right.
So that aspect of the sentencing, well, let me ask you this question. The setting of a parole eligibility date is a factor, is part and parcel of the sentence, right?
Yes.
Okay. So, following up on Justice Sachs' point, that was at that time there was an opportunity to address the issue before Judge Moriarty. However, Judge Moriarty indicated that he was not going to do so, that he didn't think that the sentence fell under 25A. Does that make a difference? Did he effectively have an opportunity to address parole eligibility date or not at that time, in your view?
Yes, I mean, I think when he set the parole eligibility, I think it would have been in light of what the defendant presented at his original sentencing hearing. I don't think there was going to be anything that the defendant could have added that would have changed the judge's mind, because the judge was intimately familiar with the case, the facts, what the defendant argued at his sentencing hearing. I don't see what else would have been what could have been achieved by having the defendant say the exact same things at a second sentencing hearing.
I wanted to ask, assume that, is the claim that there was a procedural error in the sentencing, not that the sentence itself was outside the statutory range or that no discretion was exercised, is the claim that there was a procedural error one that we can hear? Is that an illegal sentence that's within our jurisdiction to review versus something that goes to the appellate division?
It's not something that I had considered. I don't think I'm ready to address that question. Now, I don't think there is a procedural error here. In my experience, when there is an illegal sentence, what happens is it's resolved on the papers. And the court will administratively, if a motion is filed, the motion is accepted, denied, there's a ruling on the motion, and then the sentence is corrected on the papers, on the docket. There isn't a second hearing. So I don't think there is a procedural error here. If there are no further questions, I would rest on my brief.
There wouldn't be a second, I'm going to ask you one final question. There wouldn't be a second hearing, but suppose that Justice Moriarty had already retired at the time the motion to correct sentence was addressed. Right. And so sentencing was initially held before a second and different judge. In that circumstance, would there be a requirement for a hearing, a sentencing hearing?
I don't believe so, because it's just a matter of correcting the illegal sentence, just a matter of applying a parole eligibility date.
And presumably the new judge could read the transcript of the old sentencing hearing.
Correct, and I think that's the position that Judge Davis took, is that he familiarized himself with what had transpired during the original trial, had reviewed himself with the Judge Moriarty's decision, said, I am familiar with the record. Where this is an imposition hearing rather than a sentencing hearing, I'm not going to entertain it, but if I'm wrong, this is why, these are my findings.
I've reviewed the record, I've reviewed the information, and I would exercise my discretion to entertain, not entertain, but to impose the same sentence, is what he said.
Correct.
Okay. I'm all set.
Okay.
Thank you.
Thank you very much. Thank you both. Okay. Next case on our list is Alexander, and we have a little trouble with his last name, Miropolsky. I'm going to wait till you come up here and pronounce it for me, then I'll repeat it for the record, versus William Campbell, 2023-0401.
Can I speak to you a second?
Is it
Good morning, Your
Miropolsky?
Honors.
Is it Miropolsky?
Very close, Your Honor. Mirapolsky.
Okay.
Yes.
1 second. All right, just for the record, I'll say that we have no appellee brief filed and no one here representing the appellee. So please go forward.
Thank you, Your Honor. Good morning, and may it please the Court. Benjamin Timon for the appellants Alexander and Larissa Miropolsky. This case arises from a 3-week jury trial that occurred in 2022 in Middlesex Superior Court relating to a defectively constructed residential subdivision, roadway, and associated infrastructure.
Let me just ask a preliminary question. When did your clients purchase the property?
My clients purchased the property, I believe, Your Honor, in approximately 2016 or 17, pre-subdivision.
Pre-subdivision?
Yes.
And am I also correct that the easement is essentially the new roadways in the subdivision?
That's correct. That's right. And so the easement agreement was necessary, Your Honor, because it proposed to build the subdivision roadway on the land of my clients.
Got to be able to get from house.
That's right.
To get to houses 2 and 3. Let's call
That's
the.
right. That's right.
Let's call the existing home,
House 1.
House 1, and
Yes.
the other's house 2 and 3.
Sure.
And your clients bought house 1.
Correct. They bought house 1, and at the simultaneous with the closing of house 1, they entered into the easement agreement. And so they knew coming in that there would be a subdivision built there eventually. And as I point out in the brief, and as was the major...
Say your clients entered into the easement agreement?
Well, yes, Your Honor. Let me just...
They benefited from the easement, but did they
Yes, I'm
actually-
sorry. Yes, it was in place at the time of their closing, and they are the beneficiaries of that easement agreement as the owners of the so-called house lot, or House 1 in our construction here.
And you're relying on, this is at Record Appendix Volume 1, pages 92 and 93, the indemnification provision
That's right, Your Honor.
states in relevant part, I don't want to read the whole thing, but there's this phrase that says, resulting from the exercise of the easements granted herein and for entry upon and activities performed within the access easement area.
That's right.
What does resulting from modify?
The resulting from modifies claims of damage to personal property, injury, or death. And so the part of the clause that says, and for entry upon and activities performed within the access easement area, that entry upon and activities performed within is one of the three claims.
Why doesn't resulting from modify, 1, the exercise of the easements granted herein, and 2, for entry upon and activities performed within the access easement area?
Your Honor, because grammatically, there's more reasons than just the grammar, but grammatically, it would not make any sense for this to be read as follows. Any claim of damage to personal property, injury, or death to persons for entry upon and activities performed. So in other words, if entry upon and activities performed within is not a separate claim, the only other alternative is that language for entry upon modifies property damage and injury or death, and just grammatically that doesn't make any sense.
So are you saying that the for entry upon phrase modifies the claim of damage?
That's correct. Okay. Right, so there are three types of claims, and I would grant you that if the drafter of this had inserted an Oxford comma after the word herein, it would be a little bit easier of an argument, but it's still the only interpretation that makes sense, because the three different claims are, again, claim for damage to personal property, 1, injury or death to persons resulting from the exercise of the easements granted, 2, and now I said earlier that from the exercise of may also have modified damage to personal property. That would make grammatical sense. But 3, and for entry upon and activities performed within the access easement area. The other reason why that language should be interpreted that way, Your Honors, is reading of the entire indemnification clause in context. And so the indemnification clause is all about indemnifying the owners of the house lot, my clients, the Miropolskys, from, and this is on RA 192, the beginning of the clause, all costs associated with said exercise of rights granted hereunder, and the owners of the remaining land, which are the developers, the appellees, the Campbells, installing certain subdivision improvements, restoring any land of the servient estate, which would be my client's property, disturbed in the exercise of rights granted hereunder, promptly and in a reasonable fashion consistent with the surrounding land and free of refuse. There's a 12-month provision, and it goes on and requires good and workmanlike construction, etc., and the minimization of all disturbance to the use and enjoyment of the house lot, which again is my client's land. The way we laid this out at the trial in our successful verdict on cross claims for breach of easement, the Campbells claimed that the Miropolskys breached the easement. We claimed the opposite. The jury, after a 3-week trial, determined that indeed the Campbells had breached, the Miropolskys had not breached. The breach theory that we laid out at trial talked about the 4 pillars of this indemnification agreement, those pillars being the 12-month time period, the good and workmanlike manner, the elimination of refuse, and the restoration of the land. So the only obligations that exist in the indemnification agreement as between the Campbells and the Miropolskys were the Campbells' obligations to make sure that when they used the Miropolskys' land to build the subdivision roadway, that they met those particular obligations. And so it makes sense that, again, the third claim for indemnification is the entry upon and activities performed, because the entry upon and the activities performed in the access easement area, my client's land, are those things that the same clause says the Campbells are obligated to ensure take place.
I've never seen an indemnification provision like this apply to direct party claims, but it is a unique language. So I guess that leads to my question: what's your best authority that this applies here?
Yes, Your Honor.
Direct party claims.
Right. So it's really the authority that we start with on page 30 of our brief, and it happens to be a First Circuit case, but it collects a series of Massachusetts cases. The
Caldwell Tanks, right?
Caldwell Tanks, that's right.
Okay, but Caldwell Tanks says, and it notes, it distinguishes certain, it highlights certain cases and then says, but those cases were the reverse of this one. They're the indemnities sought to recover their own self-inflicted costs incurred in prosecuting affirmative claims against an indemnitor.
That's right, Your Honor.
The situation exemplified by those cases, the indemnitor has strong arguments that should not be required to reimburse attorney's fees over which it had no control for suits against it by an indemnity. So why doesn't that language hurt your case?
Well, because it does not, I mean, it makes that point, Your Honor, but it doesn't rule out the general principles that that case and many other cases talk about, which, for example, there's nothing in the word indemnity that limits it to third parties, that indemnification contracts, quote, are to be fairly and reasonably construed to ascertain the intention of the parties to effectuate their purpose. That's actually the Rule 128 decision of this court, Kuziak, on page 31, 79 Mass App Court 1102.
So we use, that's actually something I found interesting. So we use usual rules of contract construction.
Right.
But there appears to be a requirement in these cases that we go slightly beyond the plain language and look to the intent of the parties.
Which I think is fine for purposes of our case, Your Honor, because again, the Campbells in that paragraph 2 of the indemnification agreement are saying, we promise to do these 4 things, and if you're damaged by our entry upon your land and the activities that we're going to perform as the contractors on your land, and you're damaged by, you have damage claims with any claims, is the language that it uses, any claims, then the indemnification kicks in. I mean, I think it's...
So we promise that this roadway is going to be finished by June.
Right.
And then it's finished in July. This is a hypothetical, obviously. And you bring suit saying, hey, you promised June, turned out to be July.
Right.
So you breached this easement agreement, and the case goes to trial, and the jury awards you $1. You're still entitled to full attorney's fees on that case?
I would say on those bare facts, it would be unlikely certainly under a sort of traditional lodestar analysis as well. But here, that was one of 4 types of breaches that we presented to the jury. There was expert testimony about the deficiency of the roadway itself, the cost to repair it, and so on, which, borne by my clients. And so there, the jury looked at a number of different ways that my clients were damaged. And, the indemnification issue, of course, went to the judge. So, what he had to deal with was a very clear expression by the jury that the Miropolskys were right. They had been the victim of a breach. The Campbells were wrong. And again, the Miropolskys, and this speaks to perhaps the Caldwell Tanks issue, the Miropolskys were defending against a cross-claim for breach of easement during this entire process.
I did want to ask about the defense costs.
Yes.
Assuming that we agree with you that you're entitled to some attorney's fees, there are actually 3 categories of fees that I wanted to ask about how they are covered by this language. The first is your costs for defending against the defendant's claims, trespass and maybe another one, breach. Second is your unsuccessful trespass and nuisance claims.
Right.
And third is the category of work with the town and the planning board, either to enforce the easement agreement, which I'm not sure how they have any authority to do, or to enforce the subdivision approval decision. How are any of those three categories encompassed by the indemnification language?
Okay. Well, so with respect to the breach of easement, category 1, if I understood the categorization correctly, Your Honor.
Successful defense against their trespass claim.
Oh, trespass, I'm sorry, yes, right. The trespass claim, Your Honor, is, well, let me sort of, if I may, I think this may address your question. I think that if we prevail on our argument that the Superior Court judge erred in finding that the indemnification clause does not apply, there would need to be a remand to the Superior Court where the fees, where essentially there would be a hearing on our fee award. We, in our papers, asked for that in the context of supplementing.
But you didn't break out the three categories of costs that I'm talking about.
We did not break those out.
Do you claim that you're entitled to those? Because if you're not, and if we were to remand to some unfortunate judge who didn't preside over the trial,
right,
then I'm sure the judge would appreciate the guidance.
Yes. So, with respect to our, I'm sorry. Yeah.
No, go ahead.
No. So, with respect to our successful defense of trespass, Your Honor, I would concede that it's not covered because that was an allegation on the part of the Campbells that the Miropolskys trespassed on their land.
Okay.
And
what about your unsuccessful trespass and nuisance claims?
We lost on those.
Right. So you don't get fees?
We do not. Yes. This would be, Your Honor, for our successful pursuit as a plaintiff of breach of easement and our successful defense of the Campbell's breach of easement claim. Now, with respect to the planning board, which was the third category, I would contend, Your Honor, that that is covered because the planning board proceedings were attempts to enforce the subdivision approval agreement itself, which mirrored in large respects the easement agreement. In other words, I think as Justice Neyman, I'm sorry if I mispronounced here.
It's Neyman, but you did better than most, so that's fine.
I should remember that because it's Timon. So the easement agreement essentially set forth what the parameters of the subdivision construction would be. Mm-hmm. And the planning board subdivision approval decision validated that, followed.
Okay.
Yes.
So say you got everything that you wanted by going to the planning board.
Right.
Based on enforcing the subdivision approval decision.
Right.
Could you then go into court and say, hey, if I'd filed here, I could have gotten the same under the breach of contract, so therefore I should get my fees for what I did at the planning board?
Well, perhaps if we had won, but the planning board, found against us, and that was one of the reasons why we had to pursue action in court. I mean, obviously.
So that's another unsuccessful claim?
No, I don't think that's right, Your Honor. I mean, we were unsuccessful in front of the planning board, but that doesn't mean that, I don't think that triggers non-applicability of this in the same way that an unsuccessful court claim for nuisance, for example, would. We sought enforcement at the planning board. Part of the Superior Court decision was essentially challenging that and winning relief on the tenets of the...
But I didn't see an appeal under...
No, it wasn't. Procedurally, no, Your Honor, but what I'm saying is that we made the same arguments at the planning board that, that the Campbells had obligations that ran concurrently between the subdivision approval plan and the easement agreement, like good and workmanlike construction, for example. There was bond activity that we, litigated at the planning board to try to have them not release a bond, et cetera, so that some of those deficiencies could be funded. And so, yes, we were unsuccessful at the planning board, but we were successful in the Superior Court on breach of easement, which in effect gave us the relief that we had not gotten at the planning board, but were challenging from a practical standpoint in the court proceedings.
So you could have gone right to Superior Court. You didn't have to exhaust remedies at the planning board.
There was not yet, that's correct, there was not an exhaustion issue with respect to.
Do you have any case law that suggested in a situation like this where you've got both an administrative and a judicial remedy, that if you lose on the administrative and then you go pursue the judicial remedy and win, you nevertheless, you get fees both for the judicial work and for the work at the administrative level?
I do not have such authority to cite to you, Your Honor.
I'll set with your questions.
Thank you
Your
very
time
much.
is up, and thank you for answering all of our questions. We appreciate it.
Appreciate it. Thank you.
I'm going to confer with the panel before we call the next case.
I wouldn't mind taking a break, but I'll defer to Eric.
All right, so I've conferred with the panel. We're going to take our short morning recess right now, and then we'll hear the last two cases when we return. Thank you all for your patience while we had our breaks. So the next case is partially impounded, JN versus KB, 2024-1458.
Good morning, Your Honors. May it please the Court. Jeffrey Pickering on behalf of the appellant. Also present with me is my co-counsel, Attorney Soraya Sadgi. Your Honors, this is a consolidated appeal of 2 restraining order extensions, one that was extended July 1st, 2024, the second on September 4th, 2024. The initial order was obtained June 17th of 2024 ex parte by the plaintiff, or also referred to as mother, from the Framingham District Court. Just for a way of background, the parties were...
I think we've got the facts.
Understood. Okay, thank you.
I had a question which might simplify this argument. I want to understand what's still at issue, if anything, with respect to the order regarding the children, because the parties seem to agree at the September 4th hearing that things are back to status quo with respect to parenting time and custody, and there's also a stipulation, I think, in the record from the probate court from January of 2025 that says paragraph 7 and 8 of the restraining order shall be vacated. So we couldn't do, even if we agreed with all of your arguments, we couldn't do anything other than vacate the restraining order. So if the portions regarding the children have already been vacated, explicitly or in effect, then I'm wondering whether we need to even talk about that aspect of the order and whether we can just focus on the mother.
Well, Your Honor, at this point, the entire restraining order actually has been vacated. It was vacated in September by agreement of the parties. So at this
Prior
point...
to this September 3rd hearing or at it?
It was at the September 3rd, 2025 hearing.
Thank you.
At the...
25. So
yes.
You're appealing the September 4th of 24 extension.
Correct.
But at the renewal or the extension hearing in 25, it was all vacated.
Correct. It was
You're
vacated by
arguing
agreement.
it's not moot because of potential collateral consequences. Is that correct?
Correct. And, this is my client's a state trooper, and this has affected his job at very serious consequences.
I want to make sure, did the parties stipulate that it would be vacated or just that it would not be extended? Because there's a difference.
I apologize, I don't. It was stipulated that it would be vacated, Your Honor. That's what it was stipulated at the time. We were not counsel at that hearing. Yeah. My understanding is it was stipulated that it would be vacated.
Well, then what more could we do?
We're asking that the order issued on July 1st, 2024 be vacated, and the order issued on September 3rd, 2024 be vacated. And I understand at this point there is no active restraining order, but these are still things that are on appellant's record that are going to show up in the future for him and that might have an effect on his job.
Well, the order in effect at the renewal hearing in September of 25 was
Yes.
Presumably the order issued on September 4th of 24, perhaps with any other modifications that the probate court made.
Yes.
So if you, by saying you agreed to vacate it in 25, what were you vacating? The order issued in 24, it has to be.
They agreed that, and again, I was not present, and I apologize for not having all the facts on that, but they agreed not to move forward with the restraining order. And I don't know if it was, it appears it was a matter of agreeing to vacate it, and it expired by operation of law. So I think they agreed not to move forward at that point with the extension of the restraining order. But again, the order still stands as having been on my client's record in terms of future effect.
Well, I think it's important for us to get straight, and maybe with our panel chief's concurrence, we can get you to submit something. Maybe the parties can agree afterwards about what is the status of those orders that were issued in July and September of 24. Because if they've been vacated, then this case may be moot.
Mm-hmm.
And I can certainly look into that, Your Honor, and submit something to the court after.
Yeah, and
leave of the court.
and an understanding of what collateral consequences you're arguing, if they have in fact been vacated.
I understand, Your Honor. And if I can address, so starting with the July 2024 order, one of the major errors we submit is that there was a consideration of coercive control. That time coercive control had been adopted by the legislature, had not taken effect in terms of amending the definition of abuse under 209A. However,
Any authority at that time, though, that that could be a factor that could be considered by courts or by
I don't believe
judges?
so. I do not believe the statute.
No authority whatsoever, no case law, no commentary, nothing?
Not to my knowledge. I don't believe the statute itself allowed for retroactive effect. And so this was July 1st, 2024. Course of control didn't take effect till September 18th of 2024. But it's very clear that the trial court did consider course of control. It was brought up by mother's counsel. The court said, quote, "I'll consider it," Record Appendix 47 to 48. The trial court also said, "I can take judicial notice of it," meaning the course of control statute. There was the allowance by the trial court of the testimony of an expert, a so-called expert in coercive control. She was allowed to testify. It was stated that she, quote, "specializes in domestic violence."
You know, I'd like to bypass that because I don't think that's the hardest argument or the best argument that you can make. The one that I have the most questions about is whether there was reasonable fear of imminent serious physical harm, either at the July or the September hearing. So assuming that the first judge believed all of the plaintiff's testimony, why wasn't there enough to show reasonable fear of imminent serious physical harm?
So there's sort of two issues. There's her fear of herself and there's fear for the children. So the only testimony and evidence that were offered at the July 1st hearing about her fear was her affidavit. There was no testimony that she offered at the hearing about why she was in fear of my client. And if you look at the affidavit, this is Record Appendix 230 to 231, there's one paragraph that says this. It says, it's primarily about the children. One paragraph says, "My past experiences include sexual abuse, rape, and forced pregnancy by." Additionally, I have faced continuous post-separation harassment, including video recording, stalking through third-party surveillance, false accusations of neglect, attempted access to my private communications, and more. That was the only evidence submitted at the July 1st hearing about her reasonable fear.
And doesn't she go on, isn't there a next paragraph in which she says,
Paragraph 13.
yeah, I'm deeply concerned about my safety?
Correct, sort of as a summary.
So why
paragraph.
isn't that enough?
So as clear, so these parties were divorced in 2023. They'd been separated since 2019. Clearly, some of these things are from years in the past. Sexual abuse, rape, forced pregnancy. She doesn't give any dates, any specifics to any of these. And it's important, this was offered into evidence, is that the Middlesex Probate and Family Court, and at the time, Judge Allen, found her not credible. She had made these allegations.
I think we all agree that one judge's credibility determination at one hearing isn't binding on another judge.
I understand,
at
but
another
I
hearing.
think the point is that she had already made these allegations in the Probate and Family Court years before, was not found credible, and now she's coming to the district court saying, oh, these things that happened in the past, this makes me in fear. So there was no testimony offered by her outside of that affidavit.
Does it matter that at the July hearing, she was not asked whether everything in her affidavit was true and said yes, as is the exercise that's often gone through at these hearings?
I mean, I think it does matter. And in the September hearing, the judge specifically said, are you submitting this affidavit? That actually was not done at the July hearing. So there was no testimony offered about what was in her affidavit. And in terms of the children, and mother did testify to certain things about what the children told her. However, there was so much substantial third-party evidence that came in at that hearing. There was the testimony of a DCF worker who interviewed the children.
But that was for the judge to weigh. I mean, she can make credibility determinations, and it would have to be extraordinary for us to overturn.
I understand, but I think when you have one person saying one thing and you have many third parties, you have medical providers, you have DCF workers, you have a parenting coordinator, you have all these individuals.
Understood. Let me just go back to my original question for a second. Even if this whole order hadn't been vacated or allowed to terminate in September of 25, what about the probate court stipulation in January of 25 that says paragraphs 7 and 8 are vacated? Are the orders with respect to the children at issue anymore? Do we have to decide whether issuance of the July and September orders about, insofar as it relates to them, was warranted?
No, because, well, the July-ish order, there was nothing with the Probate and Family Court at that time. By the time September rolled around, there had been multiple amendments of the restraining order by the probate and family court to allow contact between father and the children, to allow parenting time, and also to give him sole legal custody when it came to medical decision-making. So the probate and family court had already done significant amendment of the restraining order when it came to the children.
So just to be clear, so in your view, we do not have to decide whether the July or September orders were justified insofar as they affected the children or applied to the children?
I think for the July order, I believe the court should decide, because at that point, there was, this was all the testimony about what the children had said to mother, and all these third parties saying that they didn't, things the children said to them that contradicted that. And at that point, there had not been amendments by the probate and family court.
Okay.
And if I can turn to the September restraining order hearing, standard again is that there's no presumption from the original order. It sort of has to be the burden of the plaintiff has to be reestablished at that point. It was very clear from the trial court that she did not want to hear anything that had not happened within the past 2 months. Over and over again, and I have many citations to the record, the judge at that time said, this is not a hearing to relitigate
Right, we saw that.
Yes.
What specific evidence did she exclude at the September 4th hearing in a way that prejudiced you?
She did not allow, there's a testimony of a police detective that she did
so
not.
how would that have helped you? Let's assume the police detective would have said, we investigated these allegations about the children, and we've determined beyond a shadow of a doubt that the father's version of those events is the accurate one, and the mother's is completely inaccurate. Assume the judge, or assume the detective was willing to testify to that. How would that have affected the September 4th hearing?
It would have gone to mother's credibility, and it would have, I mean, that the judge based her, as both judges did, and their extension on their evaluation of her credibility.
So
and
there's a rule of evidence that says, it's not a rule, but a principle, and it's stated at 608B of the Mass Guide. In general, specific instances of misconduct showing the witness to be untruthful are not admissible for the purpose of attacking the witness's credibility. So can you, by attacking the mother's credibility with regard to the allegations about the children, then argue to the judge she shouldn't be believed as to the allegations as to harm to herself or fear of herself? And isn't the evidence about, isn't it irrelevant, in other words?
It's not irrelevant, and I also think the issue, too, is that there was, this judge made very clear she did not want to hear anything. So she took the affidavit that was submitted June 17th, 2024, that contains instances of alleged abuse that occurred years before during the marriage. She takes that from the plaintiff and then says, I don't want to hear anything else that anything else that happened in the last 2 months.
But I just want to make clear, do we need to, is what the detective would have testified to, was it even admissible? Assuming the best case, which I think I tried to state before, of what the detective could have said, would that be admissible?
I think it was admissible because it was, the rules of evidence at a restraining order hearing are not always the same as at a typical hearing.
We don't really know what the detective would have said. Is that accurate? I mean, there's nothing in the record.
From the record.
Nothing in the record. Okay.
But again, father was denied his opportunity to present all evidence to defend himself, and I will further.
That was actually my question as well. Was there a proffer made as to what the detective might testify to?
There had been testimony at the previous hearing, and I believe it was brought up again in the September hearing that the detective had viewed video surveillance of after the alleged incident with the children, and the DCF worker testified at the first hearing about her conversations with the detective. She had not seen the video surveillance firsthand, and he had. And he had also investigated the matter through the Framingham Police Department. And I believe that was brought up to the judge in the September hearing. And I'd refer the court to Frazato v. Frazato, where it says, fairness in what evidence is admitted and relied upon must be present at a hearing. So there was not fairness. The judge she said at one point, I don't see what could have changed in the past 2 months. That's not the standard. The standard is whether or not mother or any plaintiff in a restraining order at that time has a reasonable fear of serious imminent bodily harm, and not if something's happened in the past 2 months, to change that. And especially when the affidavit, and that judge did say, is this your affidavit? Do you agree with it? That was submitted. So those are events in the past, events prior to July 1st. Clearly, mother was allowed to introduce that, but father at the same time was not allowed to introduce his own evidence. And it was
Isn't
very
that
clear.
consistent with the case law that says we can't consider the evidence underlying the original order, at least, or the basis for the original order cannot be challenged at an extension hearing?
It's different in the sense that she's relying on the same facts. So mother didn't say these things have happened to make me in fear. She's saying the same affidavit I relied upon at the first hearing is what I'm relying upon now. So she's using the same facts. And she did, when asked, she did testify, and what she testified to was the contentious nature of the parties' probate and family court litigation. She didn't say there are lies, there's motions I've defended against. This is not a basis for a restraining order. This is unfortunate unhappiness with a contentious litigation in the probate and family court.
So she does have the allegations in the affidavit, and then she testifies at the September hearing that she was in constant fear. What do we do with that?
Well, she's basing it on a litigation, saying because we have a contentious litigation, someone's filing motions against me.
I'm not sure that reference to constant fear was talking about the litigation. I think the judge asked her, do you remain in fear? And she said, constant. That was not in the midst of a discussion of litigation and worrying about getting texts or phone calls. It was
I believe
encompassing.
So I think she went on, and I would have to look at the transcript, I believe she went on to then talk about the litigation. And I think that if the constant fear is based on her affidavit, which was these things that took place prior to the marriage, and that she didn't testify any more specifics in the September hearing than she did in the first July hearing.
Thank you.
1 second, I'll let you know if we're all set. All good. Thank you very much.
Thank you, Your Honors.
Okay.
Good morning. May it please the court. My name is Jennifer Lamanna, and I represent the appellee, J.N. There was ample evidence in the record at both hearings to support each judge's independent determination that the restraining orders should be extended. As the court is aware, this is an abuse of discretion standard. And so the question is whether the decision that was made by each of those judges after the hearings that each of them conducted was within the range of reasonable alternatives. Specifically, one of the justices...
Of course. Start with a question I asked the appellant at the beginning. What's your position on whether either of those prior orders have been vacated?
So I can address, I believe that as to the children, it was vacated by the stipulations entered in the probate court and was no longer a live issue as of September 2024. As to the current status of the restraining order, I do actually have a copy of the stipulation entered into by the parties in September of 2025 and what they specifically agreed to on that date. I don't have the transcript. I don't know what they said at the hearing, but what they signed a stipulation agreeing to was that the restraining order would be vacated as of September 29th, 2025.
Okay.
Okay. I don't know what that means.
Or either. I was not counsel at that, but that is what the stipulation itself says.
In your view, or in the mother's view, is the issuance of those two earlier orders, insofar as it related to the children, is that moot, or does that still need to be decided because of collateral consequences to the father?
Well, where the parties themselves stipulated to the vacation of that order, or any terms regarding the stay away or the no abuse, I would say that it is moot as to the children. It's certainly not moot as to my client, and that really, I think, is where the collateral consequences, to the extent there's not much discussion of them in the brief, but to the extent that there are collateral consequences, they would arise from the continuation of the order as to the mother.
Until September 2025.
The brief was filed before the order was vacated, correct?
Correct, Your Honor. That's correct.
So there would not have been, I don't know when the reply brief was filed, but I assume that was filed as well.
That was filed after as well. And there's going to be ongoing litigation
That was
about
filed,
that.
sorry, the reply brief was filed before the order was vacated,
Prior
correct?
to September 29th, 2025. That's
Right,
correct.
So there wouldn't have been an opportunity in there to argue for collateral consequences.
Yes, but I was referring with regard to whether there were collateral consequences as to the children.
Understood.
There's no discussion of that in the brief.
Okay.
With regard to, I believe, Justice Neyman, you had asked whether or not a specific proffer was made as to Detective Crawford, and I wanted to reference, Your Honor, the specific part of the argument at page 143, where the only proffer that was made is that Detective Crawford, it was not about mother's credibility, is that he would testify as to what he had learned during the investigation. To the extent that it's now being argued that Detective Crawford should have been allowed to testify because he had specific information relative to the mother's credibility that was not raised at the lower court level.
Criminal allegation, which was the impetus of this 209A.
Correct. That's correct. And with regard, it's troubling as you read these references to the September judge was accused of having placed undue weight on what the findings were of the July judge, but it was in fact the defendant's counsel, the appellant's counsel, who offered the transcript of that prior hearing into evidence and urged the judge to consider that. With regard to the reasonable, and the judge said, that's a separate hearing. This is a new hearing. I'm not relitigating that. I have to make findings as to whether she's in fear today. And with regard to Justice Sachs' question about whether there was reasonable fear, elicited from the plaintiff's testimony at the September hearing. At one point in the transcript, the plaintiff began specifically describing that she had been sexually abused during the marriage, and the judge stopped her and said, look, I understand this is going to your fear. You have already told me that your affidavit is true.
That troubled me because the plaintiff's about to explain something, and the judge says, oh, I know what you're going to say. I know that you're still in fear because of these allegations of sexual abuse. And then the plaintiff says yes.
And she did
Can
say...
we take that as evidence?
Well, certainly...
I mean, she hadn't said that up to that point that I see.
That's correct. She was certainly attempting to tell the court at that point. She certainly says it in her affidavit, which the judge said that she was crediting. But given that she had validated it specifically on the record and under oath at the September 4th hearing. But the judge did stop her. There did seem to be a time constraint that was driving some of the decisions that were made here. I think there are a couple of references in the transcript to the judge saying, we're concluding at 1 o'clock. I did not see any objection by either the defendant or the plaintiff's counsel as to the judge curtailing the hearing due to the time constraints. But the judge did state when she stopped the plaintiff from going on about the fear that she had, she said, it's in your affidavit, and defense counsel is going to ask you questions about that. And then, of course, defense counsel did not ask any questions about the affidavit or test the mother's credibility on those issues at all, which is concerning. I understand the court's point that perhaps the judge should have let her finish her sentence and tell her what her fear was based on and where it came from. But there was ample opportunity.
So assuming that she remained in fear, what's the evidence that it was reasonable fear?
Well, particularly where the fear that she was alleging was based on physical abuse. She was alleging rape. She was alleging
It was
forced.
sexual or...
Yes.
Yeah.
So where she was alleging that, certainly the case law establishing that, having established that she had been a victim of that sort of activity, physical abuse or forced sexual relations, that what she needed to demonstrate was that she was still feeling the effects of that prior abuse.
But that's not the theory that's being argued here. I haven't seen that. You're arguing that she remained in reasonable fear of imminent serious physical harm, not that she was still suffering the effects of the past sexual abuse and needed the protection, the emotional security, in essence, of a restraining order, like in the McIsaac case and I think the Callahan case. That wasn't the argument to the judge, at least.
It was, well, I think certainly whether or not it was the specific argument made to the judge, there was, as we were just discussing a moment ago, there was some limitations on the time available to both parties to argue and present their cases. But regardless of whether it was argued at the end, the evidence that was before the court was that this was a plaintiff appearing with these significant, serious allegations.
But if this is an abuse of discretion standard, and we have no indication that the judge used her discretion to say, is she still suffering the effects of the alleged sexual abuse during the marriage.
I think
If she didn't exercise her discretion on that, then how can we uphold the order on that basis?
What I would say to that is, at one point, she does actually address that. She actually intercedes at some point in the questioning of the defendant. And she says to him, because he says, there's nothing here, she's not saying anything. And the judge says, she does make some very serious allegations about what happened during your relationship. And she addresses it there. So she was certainly considering it. And given that the standard under an abuse of discretion is that the judge's decision is outside the range of reasonable alternatives, I don't think the fact that the judge didn't specifically say, I am finding that she is still feeling the effects of the sexual abuse during the marriage in her presentation to me today, means that this court can overturn that decision as being outside the range of reasonable alternatives.
So we have to assume that she considered that relevant factor of the case law from Callahan and McIsaac and the other cases about.
Well, I hate the phrase "we have to assume," because obviously you don't have to assume anything, but I think where it is clear and apparent from the record that that information was available to the court, it would be improper to assume that the court did not take that into consideration.
And if we don't take that into consideration, is there still, what's the evidence that her fear at the time of the September hearing was reasonable?
I think it's exactly what Your Honor mentioned before, that she
It's a different kind of abuse that she alleged. I mean, this was sexual abuse during the marriage that was alleged. And now she's married, she's living in a separate house, he's living in another house, got a girlfriend, apparently, at least at the time of the hearing. I think I saw some mention of that. I mean, she's not saying, I'm afraid he's going to come beat me up.
She doesn't, I don't believe that there's anything in the case law that requires her to be afraid that the identical form of abuse from which she suffered at the prior time.
But when thinking about whether past abuse creates a reasonable fear of imminent serious physical harm, the word reasonable means something. There has to be a reasonable connection between what she allegedly suffered before and what she says she's in fear of prospectively.
Oh, agreed. There has to be an objectively reasonable component that having been subjected to what she alleges was stalking, harassment, sexual abuse during the marriage, forced pregnancy, that she now, based upon his current behavior, has a reasonable fear that he will harm her again. I don't think she has to say, I'm afraid he's going to break into the house and rape me.
Well, doesn't she have to say, in essence, not the formula words, but in essence, that what she fears is imminent serious physical harm?
Mm-hmm.
There has to be some evidence of that.
There does have to be some evidence of that, again, but imminent serious physical harm. And again, I think she has, I don't want to commit to the idea that she had to say imminent serious physical harm because of what she alleges in her affidavit. And so that she is entitled, under the McIsaac and Callahan standards, to assert to the court, I have an ongoing fear of this person, which she clearly did say. And so with regard to the reasonableness of the imminence, the reasonableness component of the imminence of the harm is more generally applied to situations where someone hasn't been the victim of serious physical abuse at the hands of the defendant. And so the court is assessing this person's situations where, for example, someone's made a threat, and the court is saying this person's never put their hands on you. So what evidence do we have that some sort of physical harm to you is reasonable or imminent? But where you stand where this plaintiff stood, which is someone who was asserting to the court, and the court in its discretion found her credible, was asserting to the court that she had been the victim of an extended course of abuse and harassment during their marriage. For her to say, I continue to be in fear, for her to, again, to try to explain to the court from whence that fear came. I was raped during my marriage, and the court stopping her saying, I've read your affidavit. You'll be asked about that by defense counsel. I think that's more than sufficient under the very deferential abuse of discretion standard that this judge was operating
We
under.
also said that findings of fact, even implicit findings of fact at 209A hearings are reviewed for clear error?
Yes, absolutely. And again, so
it's not just abuse. I mean, it would be an abuse of discretion to rely on a clearly erroneous finding of fact.
It would be. I don't think that there's any, but again, since the clearly erroneous standard is so deferential, what you would have to, in order to determine that the judge clearly erred, in relying upon the plaintiff's statements of what had occurred during her marriage, for example. She testified under oath that these things had occurred. The defendant argued consistently in the brief and at the court hearings at the time that, oh, other judges found her not to be credible. That's clearly not the standard that was before that judge. This judge was not free to say, other judges don't believe you, I don't even have to hear from you. So that wasn't the case. So in order for you to say, for the court to say it was clearly erroneous to rely on her statement of reasonable fear, then you have to find beneath that there was nothing in the record to support the plaintiff's representations of fear, and that it was erroneous for the court to find her credible.
Well, it's part of her burden to show that the fear is reasonable. Would you agree
Agreed.
with that?
The burden did not shift to the defendant to show that she had that any fear she might have was unreasonable. Certainly, she had the burden of demonstrating her fear was reasonable.
So if what she alleges about what occurred in the marriage is true, what makes her fear reasonable in September of 2024 based on the very different circumstances in which the parties are living at that point? They're no longer married, they're no longer living together, she's got a new husband, she feels comfortable evidently either dropping off or picking up the kids at the father's house in relation to hockey practice. It doesn't, or some kind of practice. What's the evidence that what is it that she's in reasonable fear of?
Well, respectfully, I do want to say again, I don't think she had to demonstrate reasonable fear of imminent
Well, I
physical
understand
harm.
you've got a theory about McIsaac and Callahan.
But to the extent that she did have to demonstrate that given the details of, strike that, given her representations under oath as to what she had undergone during the marriage, for her now to be in a situation where the children, according to her, which the court found credible, have reported to her that the father has done something to them, that they've been told they cannot share information with her, that I believe she testified to every time the email dings or the phone rings, that she has continued fear. That based upon her experiences with him, I think it was well within the court's discretion to take that to mean, I don't know what he'll do. I know in the past he's been violent with me. I know that in the past he's harmed me. And I know that right now he is very angry. He's telling my children not to communicate with me. And we're involved in extremely contentious litigation. I think that is well within the trial court level judge's ability to discern from the statements that she made on the record.
Without meaning to split hairs, but
Sure.
That's what we do. And without meaning to get into a dispute about language, paragraph 13 of her affidavit says, my past experiences include sexual abuse, rape, and forced pregnancy. Whether that extends to violence, I mean, one can argue that any rape is violence, but is that an allegation of violence there?
I would certainly assert that it is.
What kind of violence? What kind of violence can the court assume from that description?
Sexual intercourse without her consent, the violation of her person.
But she's not in continuing fear of that in September of 24. Is she?
I can't place myself into the plaintiff's mind on that day,
Well,
but I can certainly say.
that's a way of saying, don't we need more evidence?
Well, I can certainly say that it was well within a district court judge's discretion, having read that affidavit and her having asserted that what it contained was true, is that having been the victim of that level of sexual violence, that she would use the term rape, that she would have an imminent fear of being around that person in general, which is exactly what 209A orders are designed to create. They don't create situations where you can't be alone with the plaintiff. They don't say, what they say is you must stay away from her. You must, and it creates a situation where law enforcement can intervene if that person feels afraid or if a certain zone has been violated. And I think without splitting hairs, but if we're going to say that restraining orders need to be crafted to say, you allege that you were raped, so he's not allowed to be alone with you, he's not allowed to be near you, right? Then, because in theory, that would be the only imminence, if that's all you're afraid of. You wouldn't need the protection of a broader restraining order. So I think that the statutory scheme itself that we're dealing with encompasses the fear being broader than the specific act reoccurring.
Thank you both very much for your arguments. We'll take the case under advisement. And now move to our last case on the list today. And the name of that case is Jacqueline Electric and Contracting, Inc. versus David TETREAULT and others, and it's number 2025-0750. And as happened earlier today, the appellant is going to be arguing, and there is no appellee brief filed and no representation by the appellee.
I'm sorry, I didn't hear the last thing.
I said no appellee is going to be presenting any argument in this case today.
That's correct, Judge. I have a little bit of a hearing problem, but good afternoon, Your Honors. I have to tell you, judges, that in my 60 years of practicing law, this had to be one of the most frustrating cases that I have ever encountered. And I will summarize the principal arguments for you in this case. The plaintiff is a WBE, a woman business enterprise, electrical subcontractor who hired a part-time person to become a bookkeeper who never made more than $45,000 a year.
We're familiar with the facts and what was presented at trial.
That's the background. Now, the legal issues are as follows. The evidence was literally uncontradicted, undisputed, and admitted by the defendant, both vis-a-vis his deposition testimony read at trial and his actual testimony as to the agreement here, that there was never a mutual agreement or meeting of the minds as to the amount of the compensation.
Let me back you up. Are you saying that the defendant admitted that there was no meeting of the minds? Didn't he say that all of the compensation was authorized?
No, what he said was, and it's all in, and I spent a lot of time, showing you the facts. What he said, as both through his deposition testimony and his live testimony, that they never had an agreement as to the amount of money that he was to be taking, when he was to take it, who was to determine it, how it was determined, et cetera, et cetera. When he was first hired, and this was the issue, when he was first hired, and he got $500 a week as a salary, plus he was to use the company credit card once or twice a week, as he said, not to go crazy over it. Mm-hmm. And he claims that in 2018, that he started working longer hours, as a result of which he started taking monies galore. I mean, they started off at $2,000, $3,000 a week. They got into the last year of his employment. He was taking $100,000 a day, a month. Some days he was taking $40,000 a day. And what he was doing was, as the bookkeeper, he would get the bank statements, and I didn't know you can do this, but he altered the bank statements, and he altered the books and records to hide it. He hid it from not only our client.
Let me just ask, what he testified to was, he admitted that, of course, he did that, but that, again, he said it was with the knowledge of your client.
Well, first of all, do you honestly...
I wasn't on the jury, so I can't say.
There's no person, no rational person that would ever agree to that. I mean, here was the principal of the company who never made more than $200,000, and here was a part-time employee that took $2.2 million in approximately 3 years. Do you think any rational person would have ever agreed to that? Obviously. First of all, I would have objected to if he said that she had knowledge of it. That's a conclusion. What he said was that she had access to the books, but he altered the books. And not only did she not pick it up, but her accountant, who happens to be a forensic accountant, never picked it up. And until one day, she got hold of her bank statements, the original ones from the bank, and compared them, and that's when, it was all discovered. But
Let me ask you this, and I'll use the term that you used at trial, which I think you said absurd, and what you use, the term you're using now, that no rational person. If the jury rejected everything that your client had to say and rejected the fact of even the testimony of the forensic accountant in this case, and believed the defendant, then where are you?
First of all, he never admitted that he had...
If that were the case, hypothetically, then where would you be?
He actually agreed that his whole testimony was that we never discussed money when it came to his so-called agreement. I mean, how clearer can you get than that?
So your point would be, even if that were the hypothetical that I presented, even if that would not, your directed verdict should have been allowed.
No. There's a leading case. As a matter of fact, ironically, I was the lawyer in the case.
I read the case.
The
yes.
IR&R,
yeah.
Mechanical versus Hazleton, which is the most cited case. If you ever look up in Westlaw, you'll see that it's the meeting of the minds is a material matter for a contract, and there has to be an agreement on all essential and main terms of a contract at the time that the agreement is made, period. And it's been followed God knows how many times.
So she was suing for breach of contract.
I'm sorry?
She was suing for breach of contract.
Well, you see, that's the other problem.
They had an initial agreement, at least, that he would be employed for $500 a week. The use of the credit card and company funds for other things was left a little bit sloppy and open-ended, I think the jury could reasonably conclude, by him, but also by her. So the burden is on her to prove a breach of an agreement that was made.
Well,
and how is the jury compelled to find that there was a breach of an agreement that was made if this term was left open-ended?
Would you believe that a breach of contract was not pled by me? This is something the judge made up. The judge, and this is where he also went way off. We had counts for money hadn't received and for conversion and for declaratory judgment.
He explained why those counts were not valid. Well, what was wrong with what he said specifically?
What was wrong was, first of all, he's wrong when it comes to money hadn't received. That means that's a common count that we used to use in the old days and still do. That says when you get money that it doesn't belong to you, it's an equitable remedy. Conversion, he's wrong.
Okay.
You can convert for money.
But
if we may.
Go ahead.
Yeah, he's wrong there. And as declaratory judgment judge, he never made a declaration. I asked him to make.
Hold on, 'cause there's a question that's being posed to you, okay?
I'm sorry, Judge.
So at page 446, note 1, which is the decision and order on the motion for JNOV, footnote 1 goes through in some detail with citations why the claims for embezzlement, money hadn't received, and other remedies, I think including declaration, were not valid here. What specifically is wrong with what the judge said?
Well, if you look at my motion, because I filed a motion for reconsideration, and I went through each of those remedies, citing the case law that said that he was absolutely wrong. And as far as those particular allegations, but it gets even further and more complicated because the issue here was really one of what we call mutual assent or a meeting of the minds. Did both parties agree to those terms and conditions?
Well, going back to that, the judge actually instructed the jury on that very issue, did he not?
Well, here's the issue, Judge. It's, believe it or not, it's a question of law, not, he should never have submitted it to the jury in the absence of any agreement.
No, the terms of the contract and whether
I'm
there had
sorry,
been an
Judge.
agreement was a question for the jury. And the judge actually said to the jury, and I'm quoting, "The terms of the agreement are those terms to which the parties mutually agreed." In other words, what amount of compensation did Gorman, on behalf of Jacqueline Electric and TETREAULT, agree that Jacqueline Electric would pay TETREAULT? And then he went on to explain, how they were going to go about doing that. So the issue is presented to the jury by the judge that they had to determine whether or not these other material terms had they been agreed upon.
But if you look at his decisions on judgment Northwest, JNOV, et cetera, he stated, quote, "The central issue at trial was whether Gorman authorized the defendant to take the funds. The evidence was in conflict. TETREAULT testified the owner gave him permission to compensate himself from company funds, although they never discussed a specific amount." He acknowledges everywhere that there was never an agreement about the money. Who was to decide how much it was? I mean, I never heard of an employee ever deciding how much to take, when to take it, et cetera, et cetera. And in his complete discretion, I know of no. I mean, it's not only...
Well, it was up to the jury to determine whether or not your client had proved.
Judge, I'm going to give you two citations that you ought to look at. The issue, he said it was an issue of credibility. These are two cases that say that the issue of a mutual agreement or a meeting of the minds is a question of law. The first is the SJC case of Situation Management versus Maloof, and its citation of 430 Mass 575, a 2000 case. Then the appeals court has a decision called Seabreeze Estates versus JAREMA, and that's 94 Mass App 210. It's a 2018 case. Both cases hold that the issue of credibility and as far as a mutual agreement and a meeting of the minds is a pure question of law when the evidence is...
I have to say I disagree, having reviewed those cases, and I'll refer you to a case that actually predates both those cases, and that makes clear that ordinarily the question of whether a contract has been made is one of fact. If the evidence consists only of writings or is uncontradicted, the question is for the court. Otherwise, it is for the jury. So here what we have is really an oral contract, right? Nothing was in writing.
The question of a mutual agreement or a meeting of the minds, the first thing is judge has to determine, was there any evidence of any such agreement of a meeting of the minds on all the essential and critical terms of an agreement. And
okay, sure, before the case gets submitted to the jury, the judge has to determine that there's evidence of a contract and of the term, that there's some evidence. But here the defendant testified to his understanding of what his compensation was going to be and was at the time that he was taking, admittedly, large amounts of money. Right? So there was testimony. The judge said exactly that.
Again, we can go back, and it's, first of all, he never testified that there was any agreement about how much he could take, when he could take it, et cetera, et cetera. There was never any testimony about that. As a matter of fact, he said to the contrary, we never discussed when I could take the money, how much I could take, and et cetera, et cetera. They never discussed money. He did it on his own without any agreement or even any mention of what he was doing. And frankly, this case could be a very bad precedent because if this is the law in Massachusetts, allowing an employee to determine his or her own compensation in his or her own discretion at any time or times and in any amount or amounts, God help us. I mean, that's not a meeting of the minds. And the other thing is, quite frankly, no reasonable jury could have ever believed that story. And he did admit that we never discussed money. He must have said that 100 times at the trial. And how do you have a compensation package where you don't discuss money? How much, when, how it's based upon, what it's based upon? God help us if that's the law of Massachusetts. Now, the other thing that is, the judge messed up on the jury instruction.
I do see your time is up. I don't want to...
I saw that, Judge.
cut you off, but all of your arguments that are in your brief, of course...
Yes, they are, and I rely on what I wrote in my brief.
All right.
And by the way, thank you, Your Honors. It's been a pleasure.
Thank you for your argument.
This is my last year, but believe it or not, I got
good luck to
three
you.
more appeals coming. Thank you, Your Honors, and have a good day.
Okay, that's our last case of the day, so the court will stand in recess.